Okay, it is a special session, Monday, November the 2nd, 2020, and welcome to Constitutional Law. I am Richard Wright. Everybody already knows that by now, and I'm going to spend some time talking about the assignments for um, week 5, and particularly your course project, which one person I think tried to do already. I kind of wish they had waited, but that's okay. So we're going to talk about that. So this election eve, as people get out tomorrow to go out to vote already. I've been watching the Supreme Court. Supreme Court has already started making some very interesting rulings, one involving Black Lives Matters, one involved voting, believe it or not, the counting of voting. It's all kinds of things. So it's a good, interesting thing. Oh, I will tell you this, not that this should affect the guys that are right here, but there are some people, I hope not, that are in this class next term, which actually starts a week from, let's see, next Tuesday is the last day of this class, and Wednesday is when the new class starts. So, I hope that I don't see any of my students in this class in there. I know I won't see the guys that are right in here already in there. So, but yeah, I'm going to be teaching. It's unusual for them to do that. They're doing back-to-back constitutional law uh, next term. So, very interesting, along with some other courses that you guys have already had, and that would be criminal law and drugs and crime. So those would be the 3 courses that I'll be teaching in term 2. All right, so we're going to spend a little more time together this week, and you'll see what I'm talking about. Let's get to the home page. And if you come down here, you see the assignments for week 5. Now, this is your written assignment, voluntariness of a confession. I will give you more specifics in the module, but these are to get your 80 points. Explains what a confession involuntary include reasons found through research, finds and summarizes a case where a confession was held to be involuntarily given, and explains the court's ruling, uses proper case citations, and then APA, and you know, with the cover sheet and that. All right, pretty straightforward. Now, when we get to the course project, there is an alternate course project, and it's 100 points. And actually, if you do the alternate course project, you'll probably be fare better. Both of them equal 100 points, but you'll see why when we get to that. And this is the breakdown. And I actually did this completely from scratch. And you're going to see how easy it is actually once we get to the module. Okay. You can see here that this is week 5 and our lecture taking place today. And then be aware that I'll see you guys again Thursday for the final week 6. So don't anybody think it's going to be a lecture next Tuesday, because that's the last day of class. That'd be crazy. So you'll have 2 lectures this week. All right. So let's look at the module here, week 5. Okay, so in the 5th week, we're going to deal with suspects' rights. And this is one of my favorite modules, primarily because I spent most of my time as a criminal defense attorney. and smaller part as a police officer and as a prosecutor. I spent some of my time, as some of you already know, as a paralegal also. So chapters 10 and 11 of the text, and then we're going to talk about the rights of suspects. In your discussion post, taking the fifth, and then the second one is right to an attorney. All right, and we'll talk about that in just a few minutes. Your written assignments, voluntariness of a confession, and then the Fourth Amendment project exclusionary rule. All right, and you know what that is all about there, that versus springboard to success. Let's take a look at the course calendar. And you see time is winding up. Let me move this up here. Yeah. Time is winding up. This is where we are today. And so your reading assignment is given. And then you got the PowerPoints as well, and the additional work to help you out. Your initial post on both of these discussion forums that I talked about. Live lecture for week 6 will be the 5th. And then your reply post will be due Saturday. And then Sunday, your written assignment and your Fourth Amendment and your key phrase. Okay, and then we'll talk about this on Thursday. Okay, so you see the course ends a week from tomorrow. A week from tomorrow. Close that down. Let's go to the module. So let's see what the assignments are. Okay, so now this is the interview. Now, here's what I'm going to tell you. This is why you don't have to do this assignment, because there's an alternate one that is in here that I'm going to go over with you in just a few minutes. Interview a prosecutor, a public defender, private lawyer, judge, a police officer, and find out about the area of the Fourth Amendment that you have chosen. Should be 30 minutes or longer, and you should have enough information throughout your paper as your main secondary sources. You're going to write a one-page report outlining what you covered in the interview and who your person is that you interview. Try to get a resume from that individual. Your paper should contain proper grammar and, of course, be APA. Now, because of COVID-19, we've provided the alternate assignment. If you click on this, it opens up the assignment, and then you can take a look at it. Let's take a look at it here together. And momentarily it should be opened up. Okay, now this is the assignment. Now, the Fourth Amendment alternative project, it gives the Fourth Amendment up here. This is the actual Fourth Amendment. And this is the 14th Amendment, which applies the Fourth Amendment to the states. And then a little history about the Fourth Amendment and some cases. Now, then these are landmark cases right here. Okay. Now, here's what you're going to do. This is so easy. Since that time, there's been several landmark cases. I give you the cases. I give them to you already. You don't have to research them, but you do have to go to them. Of course, you know what you need to do too. You need to brief them. It said there are many exceptions. Now, these exceptions are the ones I want you to focus on. Pick one. Did you hear me? One. One exception to the exclusionary rule. Inevitable discovery rule, independent source doctrine, knock and announce, attenuation principle, and good faith exceptions. Now, you are to research one or more of the cases provided above. Did you hear me say? One or more of the cases provided above. One or more. You want to do two? You can. But remember, it's going to be easier if you do one. And pick at least one exception to the exclusionary rule and prepare a 2-page paper. And then in the paper, provide the details of the exclusionary rule and how it applies to the Fourth Amendment. Present your position as to whether you think that the exclusionary rule is good or bad, and support your position by using the research you performed to complete this assignment. Check your grammar, spelling, and APA. All right. Now, everybody understand why I say it is easier for you to do this Fourth Amendment alternative project rather than to find somebody to do an interview? Would you prefer to do the interview or do the alternative project? Yeah, for two reasons. What about you, Ashley? You didn't say anything. Which one? Okay. She said not the interview, so that means the alt. And I got together with the dean when I taught this last spring. And that was at the early beginning of the pandemic. Yeah, and it's hard to get this done. It is very, very hard. Um, if um, if anybody knows right now with COVID, it's hard to get interviews. I have one student that said they're going to do an interview because they have somebody in their family that they can use. That's fine. That's fine. That's good and well. But most people don't have that. And it's harder. Remember, you got to have that assignment in by Sunday. So that would mean that you would have had already go looking out for somebody and doing it. But here, I've already given you the cases, and then you do some, research to support your positions here, dealing with these different doctrines as well. Okay, very, very, very easy assignment, and that's what that was my goal, was to make it easy for the students. Okay. All right, let's get that down. All right. So everybody got, I think the vote is unanimous for those who are here to do this one. All right. And actually, what I'm going to do is, never mind, I'm going to, I think, yeah, I thought I had sent it out earlier. Did any of you ever get a PDF of this alternate project assignment? I thought so. I thought I had sent it out early. Then I sent it out at the beginning of the course, right? But if you didn't, you can do the same thing here. You can I know I sent it out earlier, but I know you can also download it here and have it yourself. Okay. So make sure that you get that done. All right. Because the grade that's going to go in the grade book is still going to be the same number of points. And like I said again, this is not that difficult a thing to do. When people look at this as a one page, they might think, oh, okay, that's less than the other thing. Well, yes and no, because then you got to line up the interview, uh, 30 minutes or longer, and you should have enough information to, to do that. And I would say that it's less time to do the alternate assignment than the interview, than preparing for an interview. Would you guys agree to that with that? Yeah, yeah. If you ever had, I taught introduction to corrections, and the students had to do an interview of a corrections officer, probation officer, parole officer, or jailer. And there were students who went through the whole week, whole 5.5 weeks, and still hadn't gotten anybody. People didn't get back to them. Then there's a course of realities in criminal justice that I hate. I wish they would fix it. I'm glad they didn't give it to me again this time. I think they're going to fix that one, where you have to interview a newspaper reporter and a person, a profession. Yeah. Were you in my class for that? Oh, okay. Yeah, that's you had the personal, professional information officer, the information officer, the PIO, as well as a newspaper reporter. It was a pain. Trust me, I went through a whole lot of changes. Yeah. Okay. So Ashley, you remember the issues, how hard it was to get those two people lined up together? Yeah. So I'm trying not to, we agreed, the dean, um, who is Rikisha, uh, Rikisha Gilmore. Do you guys know her, Rikisha? Yeah, she is. She is amazing. Yeah. And then you want a funny story about her. Her dad and I actually were in law school at the same time. Oh, you met her through Leadership Academy. Yes. Her dad is a lawyer, and we both graduated the same year, 1978. He graduated from Florida, and I graduated from Northwestern. However, I was the regional director of the Black American Law Student Association, and we had the national convention that year in Chicago, and I sponsored it. And her dad came to the convention in Chicago, and I remember meeting him in Chicago, and that was before Rikisha was born. Uh, so that's a long time ago, 1978. 77 actually, 77. So anyway, she and I talked about it, and she said, "Could you come up with a project assignment?" And then Jerry Lee, who is the department chair, he said, this was good. So everybody agreed. So they put it in the course. All right. The other assignment is from your resources dealing with confession. Write a 1 to 2 page paper that include the following. Explain what would make a confession involuntary, include as many reasons, and then summarize a case where a confession was held involuntary, explain the court's ruling. Um, the leading case in that area is what? Anybody know off the top of their head? The leading case to do with confessions, interrogation and confessions. It's the leading case. I think it came out in 66. Anybody know? You don't know? Suppose I started to say this. You have the right to. Yeah, okay. All right. Miranda. Yeah. Yes, right. That's it. Um, and Miranda case is a case. Didn't I talk about this a few weeks ago about my information that I learned about Miranda from my former law professor, Fred Enbow? You guys remember me talking about that? We called him Freddie the Cop, and that he felt personally maligned because it was his techniques that were overruled by the United States Supreme Court in the case. And if you ever read the full case, you'll see in the footnotes, Enbow and I think Reed, interrogation and confessions. Well, he was my professor in my first year of law school, and he's passed away since then. But he hated Miranda. He thought Miranda was bad. Well, we call him Freddie the Cop anyway, because the fact that he always believed in heavy law enforcement, and that he didn't think criminals had any rights, those kind of things. So, excuse me. So anyway, there are techniques that are involved, and we'll be talking about that a little bit more. But anyway, so you're gonna do this now. Try not to use Miranda as the case that you are going to use. If you can mention it, you use it, of course, but don't let that be the only case. Um, Make sure there are other cases out there that are involved. All right. Take the fifth, at the Fifth Amendment, and everybody know what the Fifth Amendment is that you have the right not to testify against yourself or self-incrimination. And then when somebody takes the fifth, generally it's done at a hearing or either in court, where they refuse to answer the question based on, they'll have a little card that their lawyer gives them and have them to read it in court that says, I will not answer this question on the grounds that I may be incriminated. Basically, what they're saying is that I'm hiding something, but that means that you can't use it against them and those kinds of things. So you can recognize that the Fifth Amendment, what it does say, there's some people who get the Fifth Amendment interrogation and confessions mixed up with the Fourth Amendment. Well, the Fourth Amendment is more privacy and dealing with specifically search and seizure, while the Fifth Amendment deals with um, questioning individuals and talking, and it has to do with conversation. So you're gonna, do you think that taking the fifth makes a person look guilty? That's a question. Okay. Oh, I think I just saw what you said. Um, when a defendant does not testify on his behalf, is that, nope, that's not taking the fifth. Taking the stand. That's what that is. The fifth takes place when a person actually uh, decides, and pretty much, quite honestly, it usually is someone else that will plead the fifth rather than the actual defendant. But you'll hear that where a person may be questioned even as a witness, and you'll ask them specific questions on the stand, and they won't answer those questions, um, such as, if you look at and pay attention to, you'll see it a lot in congressional hearings, where the fifth is I think, I'm trying to remember which one of Donald Trump's people were in a uh, Senate hearing before the Judiciary Committee, and they pled the fifth, and I can't remember who it was. Could be any of them because there was a bunch of them that did it. So really, what really takes place is um, a strategy not to put a person on the stand, which is commonly done by us defense attorneys for two reasons. Number one, a person may have a background, and if they have a background, then the prosecution can cross-examine them about that background, no matter how nice they look, or matter how much they claim they didn't commit that offense, but that can be used against them by cross-examination if they take the stand. The other reason we might not do it is because even if a person doesn't have a background, is they have diarrhea of the mouth. Anybody know what that term means? Okay. Yeah. I mean, but that's it's true. I have clients many times. We prepare them. We go over what we anticipate could be questions, and then we let them talk. And then we says, now I asked you a question that required a short answer, but you got to elaborate. Don't do that because you're getting in trouble. Less is always best. And so, yeah, but that's what we do. That's not only do we do that, but so does the prosecution. Tell them don't speak. Well, then in that case, then if they don't speak, then we might have a Fifth Amendment issue because there are questions that the judge can tell them to answer the question. Now, if they say I will not answer the question on the grounds that it might incriminate me, but yeah, the key thing is less is best. That's the key thing in a nutshell. Because what happens, a lot of people don't realize is that while they're talking, that other attorney or the other side is taking notes and they're ready to come with something that they weren't even going to ask you. I actually had a case I won with a client of mine. I told him how to answer this particular question without perjuring himself, and he answered the question. And so the prosecution went on and left it alone and went to something else. He said, counselor, later on, he says, I'm glad you told me. He said, because I would have explained it further. I said, yeah, you would have had your butt on the other side of the bars because you'd have volunteered too much information. If a defendant was on the stand and took the fifth, he would likely be hung. Well, yeah. But the point of the matter is that, well, it could create a problem there. But most attorneys, most attorneys protect their clients by not putting them on the stand. But taking the fifth is when you do try to not testify against yourself. The Sixth Amendment, right, is so important, um, which deals with the right to an attorney and the right to a speedy trial. But the big news generally is a right to an attorney. And the leading case on that is Gideon versus Wainwright. And you should be familiar with. Anybody ever heard that case, Gideon versus Wainwright? Yes. If you're taking criminal law, and I've taught it, I know you heard it. But did you learn that in criminal law, or where did you guys learn about that case? In what course? Introduction to criminal law? Probably introduction to criminal law. Because it's a foundational thing, and we're going to talk a little bit about that. So you're going to deal with the right to an attorney. Does this right have more to do with the Sixth Amendment or with the celebrity status in the OJ case? Now, notice things about OJ Simpson. He had great attorneys. But did OJ testify? Yes or no? He did not. That's correct. And the reason he didn't testify, because I actually uh, talked to Johnny Cochran before he passed, because he taught me some stuff. I took a course in '84, 10 years before the O.J. Simpson case, where I went to California and I was in a seminar, and Johnny Cochran was my section leader. His name was John Cochran then. And then 10 years later, I would see him on TV as Johnny. And then he came to Chicago and opened up a law practice with a friend of mine. And we had a chance to speak one on one. And I learned some things about the O.J. Simpson case that I talk about uh, in the realities in criminal justice class. And some interesting things that happened in that case. But my point being is that he had the dream team, but his attorneys were smart, and they didn't put him on because he was um, he was a uh, he had a background. because he really didn't have a serious background. But what he did have was he liked to hear himself speak. And, I mean, but that's because he was a celebrity and all of that type stuff. And so it would have been pretty bad. So anyway, so deal with the discussion forum and then your live classroom lecture. Any question about the assignments, especially the course project? Okay. All right, because I really wanted to make sure that people were clear. And then I don't steer students, but I do recommend in this situation that we're in with COVID. That's why we came up with the alternative assignment. Okay, because we recognize the problem right off the bat. All right. So the rights of suspects. There it is. The infamous Miranda versus Arizona. I told you it was a 66 case. And it is a landmark case. And I already told you about these warnings. And so the Supreme Court carved them out in the case. And most people know them by heart. You have the right to remain silent. Anything you say can will be used against you in the court of law. You have the right to an attorney. And if you cannot afford one will be appointed for you. Now, let me explain something to you. You see all these rights that are on here? Police officers are trained, as I was in the academy, not to try to do them from memory. Because if you mess up and leave some of them out, you open the door for a defense attorney to have the statement that you take from the individual, uh, not to satisfy the Miranda warnings. You have to make sure you get them all in. So what police officers would do is they would read their card off. They have a little card they carry, like an index card. And we had one that had each of these points. And we just read it. And every one of these points are quite clear. For example, the person, it says they must understand these rights. It is important that they understand these rights. And if they speak Spanish, for example, it should be given in Spanish, which goes back to the point that I've said in law enforcement, that because the fastest growing population in the United States, bar none, is Hispanic. If you've been paying attention to the election, you've been hearing that as well. But Miranda warning should be given so that the person understands it. If it's Polish, it needs to be Polish, or whatever the language, because they can't waive something that they don't understand. All right. So now notice this about Miranda. Voluntary intoxication is not a defense to voluntariness. So that means if you get drunk on drugs before you get arrested, you cannot later claim that you didn't voluntarily waive your rights to due to your intoxication. However, if you were drugged unknowingly, you may be able to contest the voluntariness of the waiver. So it kind of is interesting, and I think that could be litigated too as well, because whether you are voluntarily drunk or not, would you have the capacity to really understand things that are going on in some cases, in most cases? Would you? No, you wouldn't. And that's been argued. And actually, there are some cases out there that deal with that particular issue. So the point that it is not this is not a defense to voluntariness. I have seen otherwise. Where a person is high on drugs and you're going to interrogate them about a crime, I think you're taking a chance. And there are some cases that cause that to be thrown out because you're taking advantage of the circumstances of that individual. Now, here's something else that you can do. And this is actually a biscuit that was thrown to Professor Inbal and his partner, John Reed. John Reed, and he did another book called Truth Detector, something like that. It was about the so-called lie detector test, which he didn't like that name at all. But the polygraph test is what they refer to. But an officer can lie or tell stories to a suspect to get them to talk. For example, it's common, they have good cop, bad cop, where one cop pretends to be the friend of the individual and will get that person to relax, and then they will tell. But that's a routine. So an officer can tell the suspect that if he's honest with the officer and tells the officer everything that happened, he will get to leave custody, even if that's not true. Again, trickery, but what does the warning says? It says you have the right to remain silent, and we drum it into our clients' heads. Silent means silent. That's it. Period. All right. And incidentally, when does the Miranda right? When are the Miranda rights kick in? When a person is in what status? In custody. And I'm so glad you said that, because a lot of people say under arrest. I say, okay, then I have to ask the question, what does that mean? What does that simply mean when they say you're in custody? What does that mean? Holy cow. Cynthia Robinson. If I had some bells to ring, I would ring them for you because that's that's dead on to the point. That is exactly what it is. You don't have here we always used to ask people, said if they want to know whether or not they're under arrest or in custody, ask if they can go. If can I go? And they say if they say no, then there it is right there. Now, if now what the Terry stop, which is the short, the brief stop, the stop and frisk thing, it can't last long. But if it's going to be lasting a long time, then that's custodial. And then you should give the rights. Where we used to train officers and where we were trained in the academy is give the rights right away anyway. And the reason is because if somebody says something after that, then you can do it. But if a person starts to talk and then you have to, before you can respond to the questions or statements that they make, you better give them the warnings. Otherwise, the case could be tossed out. Uh, it says that the rights can be invoked at any time during the interview. Soon as the person says that, uh, you have to stop it. One of the ways that commonly they stop it is, I want an attorney, because it's one of the points. Now, when they say that, if you come back a little later, they say, I changed my mind. Don't do it. Don't do it. It'll get tossed out every time. And you have to stop the interrogation. The only way it's going to start up is when the attorney comes, or if they're let go and then they're rearrested. Then in that case, then you can end up doing it. A suspect must actually verbally invoke it. You know, the suspect's silence is not enough to be considered invocation of the rights. That's based on a 2010 case. So, I mean, but we always said that that's an interesting case, and I remember this case that um, and it came after I had retired because I retired in 2000. So this was actually 10 years ago. Wow, didn't seem like it, but it was. And in that case, the silence um, uh, was not just enough. So did the person include their exercise their Miranda rights? Not really. They just didn't talk. That's all. But that's you can't get it unless now you beat it out of them. Now we already know about what that means. So a suspect must be in custody, and we already said that, subject to interrogation in order to receive the warnings. And there's a whole line of cases that deal with that issue. Um, what exactly is custody? But you already know. I mean, you reduced it to you just can't go. All right. So, what about this? A person is surrounded by police and they're in the middle and they're asking questions of them. Does that actually put them in custody? Yes or no? Some say yes, some say no. And the answer is it depends. The answer is possibly yes, because the person is not free to go. But there must be an understanding. Now, what they cannot do is voluntarily do something if they're in a situation like that. Remember, we talked about this before that regarding voluntarily allowing a search in the Fourth Amendment sense. If a person has a gun on somebody or in those situations and they say yes, then that's not really voluntary. You remember that? We I think that was either last week or week before last we talked about that issue. So anyway, there's a whole line of cases and you can click on this and it'll open it up for you. Well, I'll show you. Okay, should be the cases. Did they take them out? They did so much stuff to this thing. Oh, okay, they just gave some ideas. Wow, they took them out. Okay, oh, they gave some issues here. Okay, I knew it was somewhere still in here. Arrest warrant, search and seizure, assault. Yeah, they took it out. It was in here. But anyway, you can find that readily about cases that support that proposition. Self-incrimination. Let's get this out of the way. So the Fifth Amendment, we already talked about that, referring to during a legal proceeding that if they believe that they will incriminate themselves, and this is outside the ears of the jury. So if it does happen in front of the jury, um, it could end up being a mistrial. Is that what you were trying to say earlier? Somebody said, is that what you were talking about? And who said it? Yes, it could be a mistrial. And generally prior to any testimony given. So if in the middle of a legal proceeding, a judge will recess the jury and inquire further. If the judge agrees that he will incriminate himself, then the other side may request a mistrial. So it could result in a mistrial. That's the answer to that. But usually there's a special proceeding to deal with that issue. But if it comes in the course of the regular trial, it is. But and where it came from, pleading the fifth, is the Fifth Amendment. Okay, it says the whole thing gives all kinds of stuff. Um, and here it talks to the fact that you can't be held for a capital or infamous crime unless by indictment or grand jury, um, when an actual service time is a war, nor shall any person for the same offense to be twice put in jeopardy, that's double jeopardy, nor be compelled, here it is right here, in any criminal case to be a witness against himself. That's what it means. That's where that fifth comes from. So when they're taking the fifth, they're relying on that little clause in the Fifth Amendment. Under the Fifth Amendment, a person can, again, stop the questioning, because Miranda deals with the Fifth Amendment. That's the essence of interrogation in itself. So now let's look at the Sixth Amendment. The Sixth Amendment, as I said before, is the right to counsel, and with the presence of counsel, and you also saw that in Miranda as well. For example, reading these two examples here, but this one is really good here. If Officer H brings in Sam to the station to interrogate him because Sam is a suspect in a retail theft case, Officer H must advise Sam of his Miranda warnings. We talked about that earlier. If Sam says, "I want my attorney," then he must wait until Sam's attorney is present before continuing the interrogation. If Sam is held in jail and later formally charged, Officer H cannot question Sam again without his attorney present. So once he does it, he has to do it at all times. But let's say, as I shared with you earlier, that if Sam was released and no charges were filed, and if the officer brought him to interrogate him again at a later date, then the officer would then likely have to give Sam his Miranda warnings again, because those from before no longer exist because he's been released, and Sam would have to invoke his right to counsel again. If Sam did not invoke this time, the court would probably find that Sam's statements at the second interrogation would be allowed in the evidence, because time had passed between the invocation and clearly Sam understood his rights. So it kind of helps out in terms of understanding that. What we try to tell our attorney clients is, don't talk unless I'm present. You can ask for me, and but I want my attorney. And then you get that call that you can make there as well. If a suspect is in custody on one charge, this one is kind of tricky, and while that charge is pending, the police are investigating him in another crime, and they bring him in the interrogation room to ask him about these new crimes, the suspect must be given new warnings, again, because it's on something separate. The suspect also must invoke their right to counsel. However, the police may not question him regardless of the case that is already pending, for which he was already charged without his lawyer present. So you see the protection of the individual, and what it does is it gives the individual a clear protection in terms of his right to counsel or her right to counsel. Okay, for example, if Sam is charged with the retail theft and he is later brought into custodial interrogation, and you know what that means, he can't go, regarding a domestic violence crime, Officer H must advise him of his Miranda warnings, and Sam has to invoke that he don't want to talk, or he wants his attorney. But Officer H cannot ask Sam about the retail theft, since the Sixth Amendment protects Sam and he can't be questioned without his attorney present at that time. So that's kind of pretty much how the whole thing works. It is if you ever take the time to really read this case, Miranda versus Arizona, if you stop and take a look at it, I think it's going to take you to a summary of it, but not the actual case itself. But if you, and this tells a little bit about it and explains it and stuff like that. But if you go and actually read the case itself, you will learn a whole lot of things that are very interesting. It's long, but it's very detailed. If you even in law school, I want you to know that we didn't read the full case in our criminal law class, um, and and then we also then learned how to, those of us who knew how to brief cases, we'd go to the library and read the whole case, and then we would, do a brief of it, and that would help us to understand it. So briefing is a very important tool to help you in dealing with the law. Okay, so that's all I got for tonight. Anybody have any questions? Okay, Ashley, none. Okay, Sarah, any? Cynthia? Oh, okay. No, I haven't given it yet. I'm going to tell you something funny. Uh, each of you have names of people that are in my family. Sarah, do you know? Did you ever hear me talk about your name? Sarah, spelled just like that, was my. You heard me talk about the story about my mother that was killed. Yep, that was my mom. Her name was Sarah. Yep, that was her name. Yeah, I think Ashley knew that one. And then Ashley, I have my oldest granddaughter is Mariah Ashley. That's what she calls herself. She calls herself Mariah. Mariah is her first name. So my daughter named her after a singer. Anybody know what singer that she named her after? Yes. Yep. Yep. Mariah Carey. Yeah. And I always for years called her Mariah Carey. She can't sing a lick, but I'm not Mariah. I'm talking about my Mariah. She's pretty though, but she can't sing a lick. And then Cynthia, I already told you, right, Cynthia? You know that, right? Yeah, my second sister. Yep, Cynthia. They called her Cindy a lot of times. Do they ever call you Cindy? Yeah. Okay. Sometimes we call her Scent. She hates it when we do that. Hey, Scent, what's up? Gosh. Okay, I'm gonna let you guys go. Um, give me the phrase. What do you think? Hold it. Who said it? I saw. Who said Miranda? I know Ashley said it. Did you say it, Cynthia? Yeah. What do you say, Sarah? Yeah, you're gonna say it too. I'm laughing only because of the fact that I guess I gave it away with the emphasis the way I said who said that. It is. But I don't want you to just give it to me, Miranda. I want it to be Miranda v. Arizona. That's what I want you to give me. Miranda versus or vs Arizona. That's the way I want you to give it to me. If you just give me Miranda and you just give me Arizona, then you're not going to get it. You know, I had somebody this past week. Wasn't probable cause our word last week? Wasn't it last week? Some some students gave me probable. So I said, no, you get no points for that. Somebody says you get half a point. No, it's not half right. It's either right or it's wrong. So no, so it's Miranda v. Arizona. Okay. And some people say Arizona versus Miranda. I have never heard it referred to as that. Have you ever heard it referred to as Arizona versus Miranda? No, I haven't either. It doesn't even sound right. Okay. All right. So anyway, guys, uh, I'll say good night to you. Don't forget, you have a good night. Yes, you too. Don't forget to get out and vote. If you haven't voted, go out tomorrow. I will be myself. And stay safe. This pandemic is no joke. No joke. Good. You voted last week. Good. Good. Don't do like they do in Chicago. The old saying, vote early and often. It's the old Chicago. If you're from Chicago, Illinois, you know the joke. But unfortunately, years ago when I was a kid, there was a whole lot of ballot stuffing and stuff like that. It's not happening anymore. It's not really happening for real. There's more voter suppression than ballot stuffing. Trust me, I know the facts. Anyway, see ya Thursday. Good night, guys.